When trying to understand some defenses in a criminal charge, the first thing we need to kind of talk about is who has the burden of proof in a criminal case. The Commonwealth has to prove beyond a reasonable doubt several things in a criminal case to secure a conviction. One of those is identity, that you committed the crime. The second one is jurisdiction and venue. You're in a court that has the ability to rule on the issue, and it's in the right city or county. The third thing they have to prove are the elements of the offense, that what you did meets the elements to be a crime. So when we talk about defenses of crimes, what we're talking about is it wasn't me. They can't prove identity. So you'll have alibi testimony, or you can prove it with someone else. Jurisdiction or venue. Judge, even if this matter is heard in this court doesn't have the authority to make a decision in this matter. Or when you're talking about venue, the crime, let's say the crime happened in Norfolk, and you're in a Chesapeake court. In that case, the Chesapeake court's the improper venue, and you shouldn't be convicted in that court. Now, when we talk about the elements of different crimes, they're going to vary depending on what the crime is, but there's quite a few defenses to crimes. Example, a lot of property crimes, you're breaking and entering, larcenies, property damage, trespassing. You can't steal, damage, trespass, or break and enter on your own property. So if you have a property interest, you shouldn't be convicted of those crimes. You also have affirmative defenses to things like assault and battery. So if someone attacked me and I defended myself, or I defended someone else, affirmative defenses are essentially, yes, I did assault and batter someone, but the law says I'm justified because I was defending myself or someone else. And finally, a defense that doesn't necessarily get you a not guilty, but may take you from a felony charge to a misdemeanor charge, would be stuff like in property cases, attacking the threshold of value. So you have to have a certain value, larceny $1,000 in Virginia for it to be a felony. Anything below that is a misdemeanor. If you can show that what you took, what you stole, what you damaged was worth less than $1,000, the court should reduce the charge from the felony and just convict you of the misdemeanor.